This is part 2 in my series. I'm Morgan Richardson. I'm a divorce attorney in Manhattan, and we are talking about no fault and grounds divorces. So before the enactment of no fault grounds for divorce, couples were stuck. They could be denied a divorce if they didn't meet any of the grounds requirements. So this led to legal fictions happening, legal fabrications happening, where either the two spouses together would collude to come up with fake meeting of grounds, or the law started to evolve to encompass things like, as I mentioned in my first part of the series, constructive abandonment, which is sexual inability. Now, the problem with this initially was that a determination on the finding of grounds, being guilty of grounds, sometimes can impact the financial side of the case. So if you were guilty of adultery, if you were guilty of cruel and inhuman treatment, you might be waiving certain financial rights. So even colluding with your spouse could then be dangerous, even if you both wanted the divorce. But still, what is the point of a system, a legal system that is set up so that couples will be lying, colluding and lying to the court, and it's generally understood and accepted? Is that a legal system that we really want to have in place where we know this is happening and almost encouraging it? Second, the disparity between the states and their laws on grounds led to sort of this migratory system where people could go to different states to get divorced, and they would have to meet those jurisdictional requirements, which a large number of states, you have to be living in that state for at least 6 months, maybe even a year, before you can qualify to get a divorce there. But it was requiring people then to travel around to try to find a place where they could actually get divorced. By the 1960s, courts are starting to recognize that this doesn't work anymore. And California decided, hey, you know what would be great is if we had something where we don't care about the fault. So 1969, signed by then Governor Ronald Reagan in California, the first no-fault divorce law goes on the book. A number of states follow suit, but not New York. We were late to the game. We signed this thing in 2010. We did have an out, though. You could sign a separation agreement and live under its terms for a year or more, and as long as you both mutually agreed to those terms, you could then get a divorce, and that was sort of a kind of little mini loophole. But if you were in any sort of contentious, contested situation, you were not getting that document signed.